So I've explained the very wide prohibition on a state measure that has the same effect as any form of grant or support to the energy sector. I've explained that the definition of a state aid then is applied very generously, let's say. But of course, that's not the end of the story. It would hardly be, because I've also identified the huge amount of money that flows from the governments to the energy sector. So if state aid was forbidden, how come we would have annual subsidies in the region of 122 billion? Well, the answer is that, in fact, the treaty allows the Commission to declare many forms of state aid to the energy sector to be compatible aid. And the Commission then has a great deal of discretionary power, as I'll explain to you, to review national measures and to declare them to be consistent with various objectives of European energy policy and environmental policy. So the process of screening member state measures is a very important one, and I'll talk about how that's done next. But what I want to concentrate now on is the tests for determining whether a measure is compatible aid or not. So the treaty provides us with a starting point, and we have rules in the treaty governing what we call mandatory exemptions and rules governing discretionary exemptions. So mandatory exemptions are the exemptions whereby a member state gives a consumer, for example, a voucher or a coupon to buy a certain amount of green energy per year. That's a fictitious example, but here every consumer gets the same voucher. And as long as the consumer can exchange that voucher for energy produced anywhere, and it's not limited to certain production companies or supply companies, then this type of support would fall within the mandatory exemptions. So the Commission just has to be told about it, and it just has to check that indeed this is a very open scheme and that these consumers could use their vouchers wherever they wish. However, the most common forms of support have to be assessed under what we call the discretionary exemptions. So the word says it all. The Commission may consider these types of aids to be compatible. So here it's the discretion of the Commission that's really crucial in assessing this compatibility. I should also mention that we have another treaty article which is also very important in this sector, and this is Article 106, paragraph 2 of the treaty, which governs what we call services of general economic interest, sometimes also called public service obligations. Now, the supply of electricity to certain categories of consumer is often deemed by member states to be a service of general economic interest. After all, we can't function without light and heat, and in many member states, the policy is that consumers should have affordable electricity, and member states intervene to make sure that the companies supplying electricity do so at an affordable rate. And they can justify that intervention on the grounds that the services in question are services of general economic interest. Now, it might well be the case that in requiring companies to provide energy at affordable prices, those companies make a loss. So they might need compensation from the member state. Now, that compensation then is compensating not so much an advantage given to these companies, but a disadvantage. It's rather the opposite. So you're cancelling out a disadvantage. So it should be neutral in effect. And that's why this Article 106, if we can invoke this concept of a service of general economic interest, is very important in the energy sector, and it's one that's widely used. Finally, we have something called a block exemption regulation. And as the term already indicates, this regulation actually exempts a lot of support, member state support, types of support from the requirement of notification, because the regulation already specifies the conditions under which the aid can be assumed to be compatible. So that type of aid, if it falls under the block exemption regulation, is then deemed automatically, without scrutiny by the Commission, to be compatible aid. Now, until very recently, we didn't have a regulation that applied to the energy sector, which meant that all aid measures had to be notified. However, in 2014, a new regulation came into force, which also includes the energy sector. And the hope of the Commission is that by adopting this new regulation, a great deal of rather minor aids, so minor in the forms of the monetary value, will not have to be notified anymore to the Commission. So that leaves the Commission free, gives it a free hand to concentrate on the tough cases. So these exemptions then, especially the discretionary exemptions, are framed in very broad terms. So the most important of the exemptions for the energy sector we find in Article 107(3) little c, which allows sectoral aid. Now, the article is just very vague, in fact, and says that the Commission may consider aid to a sector to be compatible insofar as it doesn't distort trade within the EU. So the Commission has a very wide scope to define what it would consider compatible. So what the Commission has done in order to give a clear signal to Member States as to how it's thinking on compatibility issues is to adopt guidelines. Now, guidelines are, from a legal point of view, soft law instruments. So they're not directives, they're not regulations, but they bind the Commission because the Commission says, I'm going to do X and Y and Z when you tell me what your state measure looks like. And the courts say, okay, because the Commission has said, I'm going to do X, Y, and Z, then the Commission has to do X, Y, and Z. The Commission has therefore limited or bound its own discretion, and it must then apply the guidelines that it has previously announced to the types of aids that the Member States notified it. So we have a new set of guidelines, the Energy and Environmental Aid Guidelines, adopted in 2014. And these guidelines are the first set of guidelines that we have that apply to the energy sector. Previously, the Commission had various guidelines governing environmental aid, which also covered promotion of renewable energy. But the new set of guidelines is much wider and covers a great deal of support for different types of activities within the energy sector. So aid to promote energy infrastructure, aid to promote renewable energy are all covered in these new guidelines. What's not covered, because it was very controversial at the time, is aid for the nuclear sector. That falls out of the guidelines and will be subject to a separate set of tests, which I'll explain in a minute. So the idea behind these guidelines is that the Commission will apply a common assessment to all forms of aid in the energy sector. So these common principles of assessment we find in the first section of the guidelines, in section 3, and these are built on the accumulated practice of the Commission and the judgments of the European Court. And essentially then the Commission wants to establish, on the basis of information provided to it by the Member State, that the measure in question meets an objective of common interest. So the Member State is actually doing something that the community likes, like promoting renewable energy, we like that. That it's targeted and necessary, so the Member State can show, well, we have to promote solar energy because it's still too expensive, it can't compete on the market alongside coal and gas and other types of fuels. They have to show that it's appropriate to address the problem and has an incentive effect. So in other words, undertakings have to change their behaviour. You have to show, well, if they didn't get the aid, they wouldn't do what we hope they would do. So this is another important principle. Now, the Commission's very keen that Member States don't spend too much money promoting energy subsidies, although, as we've seen, the amount of money that is out there is pretty high. But the Commission likes to be able, at least, to say that it can check that the aid given is limited and proportionate to what is actually necessary. So the Commission likes to be convinced that the aid that the Member State is giving is the minimum. It's not overcompensating companies. Then you have to show, well, of course, some people are getting advantages. Does that have a knock-on effect elsewhere on the economy? Does it put other companies at a disadvantage? And so the Commission has to do a balancing test. It has to weigh up the positive effects of this aid, let's say again for renewables, to achieve climate change goals, to achieve the Commission's own targets for the promotion of renewable energy in the European Union. Weigh up all those positive things against negative things. For example, that giving a lot of aid to renewables might make it very uncompetitive for the gas sector because they don't get any aid and therefore they can no longer compete with these renewable companies. A big problem, in fact, at the moment in the European Union. Lastly, everything should be transparent. Member States should publicise that these aid measures are available. So those are the general principles. As I've mentioned, the Commission has a wide discretion as to how it assesses these complex tests, how it assesses the amount of information that Member States have to submit to it. You can imagine that judges in the European courts are not too willing to do that exercise all over again. So the Commission, when it exercises its discretion, it knows that, okay, maybe the judge is looking over my shoulder, but the judge, he or she, is not reading every single thing that I have written or looking at every test that I have applied. What the courts want to know is that the Commission has not committed any manifest errors, so that it's not done something that's really, really wrong when it weighs up the advantages and disadvantages of a state aid. So, as I mentioned, we have now this general block exemption from 2014 that applies also to the energy sector. That is useful for both companies and for the Commission, because it means that if a member state gives you a measure of support that falls under this block exemption, you know that that is legal. So you can take the money and invest. You can enjoy that incentive without worrying that the Commission might be concerned that this is some form of state aid that they don't know about. But there are limitations, there are conditions in the block exemption. I just mentioned one. Article 41 allows for state aid for renewable projects up to 15 million per year in any one member state. And there are other conditions as well. So we have to be very careful when we claim that the block exemption applies. We have to look very carefully at all the conditions in the block exemption. So, to sum up, what should a member state do? What kind of strategy should a member state adopt when notifying a measure of support in the energy sector to the Commission? We assume the block exemption doesn't apply. We assume the aid measure or scheme involves much more than 15 billion per year. So they have to tell the Commission, okay, this is what we're thinking about. But it might well be that the first line of argument that the member state will adopt is, we've got this measure, but we don't think it's aid at all. We think that, for example, everything we're doing is market conform. We're just behaving like a market investor. So when we put money in this infrastructure company, which we own, we're doing that because we're acting just like any other shareholder. That's one possibility. Another possibility is to invoke what we call the Altmark criteria. It's going back then to the concept of services of general economic interest. So Altmark is a case which the court handed down in 2000, where the court said if member states want to say, okay, all I'm doing is compensating for a disadvantage that I'm imposing on a company, telling it to perform these services, then you can claim that this is not state aid. But you have to show that indeed the company is properly entrusted with these services, and you have to show that you're not overcompensating the company. These are quite difficult tests to meet. So what a member state normally does is it makes those arguments, but just to be on the safe side, it will also say, well, Commission, if you don't accept that my measure is no state aid, then I want you to declare it to be compatible aid. And the member state might go for all the options open to it, so it will argue that the measure is compatible on the basis of this Article 107.3, little c of the treaty, so it's support for a particular sector. And it can then, the member state can then use the guidelines, the EEAG of 2014, which specify the principles in greater detail for having the aid to be declared compatible. It can use those and say to the Commission, you must declare my aid compatible because I meet all the tests in the guidelines. And if the member state really wants to make sure it's covered all its bases, then it could also say, well, there's another line of argument, the service of general economic interest, it might well be aid, it might not meet what we call the Altmark criteria, so we have to notify it, but you can still, and this is very important, you can still rely on the fact that you're giving money to support a service of general economic interest as an argument that the aid is compatible aid. And we have another set of guidelines the Commission issued in 2012, which tells the member state how to do that. So there are a lot of possibilities for member states to convince the Commission that their aid is compatible. And a good example of where we see that, a member state going all out, if you like, and using every possible argument is a measure that was adopted by the UK government, notified to the Commission, to support the construction of a new reactor at Hinkley Point in the UK. This is a long decision, but it's an interesting decision. First of all, because it's the nuclear sector, which is always a bit sensitive. But you see, in this decision, the member state argues there's no aid involved because the member state is giving a contract, it's called a contract for differences, and the member state says, well, we need to give this contract because if we don't, the nuclear plant will not be built on time and we're facing major generation shortages. So this is a form of service of general economic interest. The fact that we're giving support in the form of this long-term contract with an agreed price will bring the investment forward, and this is in the public good. This is a service of general economic interest. But they said if the Commission doesn't accept that, well, we have other arguments. We are giving some of the investors who will be backing this plant, we're giving them a state guarantee. And banks give guarantees, so states can give guarantees. And we're giving the guarantee on market terms. So again, no aid, because the state here is acting just like any market investor. So the decision of the Commission has to address all those arguments. And as I mentioned, member states often like to cover all their bases. So the government, in this case, the UK government, had also argued, well, the aid is compatible aid because it supports security of supply, it has environmental advantages because nuclear is low carbon. And we, the UK government, we can also rely on the fact that the treaty says we can determine our energy mix. So if we want nuclear, we want to subsidise nuclear, then that should be acceptable. This is a long decision, and I can't go into it in great detail here to do justice to the argumentation. But what's really interesting about this case is that you see then all the arguments being used by the member state to convince the Commission either that it's no aid or that it's a service of general economic interest and the market investor test is met. But if the Commission is not convinced, then there are complex arguments supported in this particular case by a lot of economic analysis as to why this type of aid meets all the conditions that the Commission would normally expect to see fulfilled. So it fulfills it's an object of common interest, the aid is proportional, and there's no risk to competition in other markets. So you see the Commission going through all those tests. So this is a very good example then of how these tests are applied in practice to declare, in this case, 95 billion sterling aid to a French producer building a nuclear plant in the UK to be compatible aid. Thank you.